Good afternoon, everybody. Thank you for being here. Today, we're going to be talking to Teresa and Elise from WorkSafeBC about Bill 41, which is the duty to cooperate and the duty to maintain employment. So a little bit of housekeeping first. Our intention today is to create a safe space for you guys to exchange knowledge and support each other. And this webinar is a total of 60 minutes. It'll be approximately a 45-minute presentation plus a 15-minute question and answer period. And we'll be taking those at the end. And all participants are muted. So if you have any questions, please use the chat feature to submit your questions. And a recording of this webinar will be posted on our website, which you will receive in an email notification. So we'll do an Indigenous Territory acknowledgement. So ActSafe Safety Association would like to acknowledge and honor that our workplace and classrooms are located on the traditional, ancestral, and unceded territory of the Kikite, Stalo, Holkuminin, Tsleil-Waututh, Musqueam, and Chemainus peoples. And if you'd like to learn more, you can go to native-land.ca. So a little bit about ActSafe. We are a not-for-profit health and safety association supporting British Columbia's arts and entertainment industries. And since 1998, we've been serving our industries by providing resources and training to employers, supervisors, and workers with the aim to have a health and safety workplace. And we're always here to provide information relevant to best practices around health and safety in the arts and entertainment industry in British Columbia. So our vision is that we have the safest and healthiest arts and entertainment workplace in the world. And our mission is to prevent and eliminate workplace injury, illness, and death by providing world-class occupational health, safety, and well-being programs to employers, supervisors, and workers. And our core values are safety, education, accessibility, collaboration, and innovation. So one of our presenters is Teresa Chung, and she is with Return to Work Consultation and Education and Return to Work Services of WorkSafeBC. So she consults with employers regarding their existing disability management program and claims process. She's worked as a vocational rehab consultant with the organization assisting injured workers in returning to work. And she's also worked with the US federal government in the Department of Homeland Security as an equal employment opportunity specialist, consulting and educating managers of airports in the management of human rights claims. And she has a master's degree in vocational rehab and Juris Doctorate degree in law. And our second presenter is Elise Kobylansky. And she is also with the Return to Work Consultation and Education and Return to Work Services at WorkSafeBC. And she's a manager of client services and a registered nurse working as a certified occupational health nurse focused on disability management in public and private sectors. So currently in her return to work consultation and education services role, she assists employers to improve their return to work outcome by implementing disability management best practices. And she has experience with Canadian Manufacturers and Exporters Association, the BC Municipalities Safety Association, the Maritime Employers Association, and the Canadian Society of Safety Engineering. And she is a certified psychological health and safety advisor for the Canadian Mental Health Association. So our agenda today, they're going to be going over legislation overview, duty to cooperate, duty to maintain employment, collective agreements, administrative penalties, and at the end, we're going to have a question and answer period. So if you have any questions, if you could put them in the chat, and we'll address them at the end of the presentation. Thank you. I will turn it over to Elise and Teresa now.
Thank you so much for that introduction, Maret. We're really happy to be here today. We are going to do an overview of Bill 41, and I'm going to begin with the duty to cooperate. But before I get started, I'll allow my colleague, Elise Kobalansi, to say hello.
Hello.
Next slide, please, Maret. Okay, so the purpose of the new legislation is that it provides a legal framework. Up until now, uh, it establishes a duty to cooperate. It establishes a duty to maintain employment. It does allow for financial consequences, but leads for better outcomes. Up until now, what we've been finding at WorkSafeBC is that people tend to play, or employers tend to play, a waiting game. Waiting for WorkSafeBC to contact them, waiting for WorkSafeBC to state that they are at their best, waiting for WorkSafeBC to come up with something. And so what we wanted to do was to pull WorkSafe out of the equation and leave the return to work in the hands of those who are best suited to deal with it, which is the employer. So conversations between the employer and the worker for cooperation and maintaining employment has been found to lead much better outcomes. So the duty to cooperate, this is the first portion of the Bill 41 that applies to most employers. The duty to cooperate, it applies to all employers and workers in BC, all of them. And so what this does is it adds a legal duty for employers and workers to cooperate in a worker's early and safe return to work. There are 4 points that I want to make on the duty to cooperate that'll help you to understand it a bit better. The first is contact. The employer and the worker should be contacting each other at the first moment practicable. What that means is unless it is harmful to the worker, for example, if they've broken a limb and they're in an ambulance, or unless it's or it's a really catastrophic injury, then we should be reaching out as soon as that injury is happening and speaking to the worker. So there's a duty for the worker to contact the employer and for the employer to contact the worker. So, and that needs to happen as soon as the injury is happening. So that is one that is pretty new for us. When I came to the board, as Maret indicated earlier, I was a vocational rehab specialist. And if you would look at the total process of a claim when it comes to WorkSafe BC, Voc Rehab is at the very end, at the very end. And a lot of times when I got that claim, my questions first for the employer were, when's the last time you spoke to the worker? And usually the response is, oh, we can. And my question to the worker was, when's the last time you've heard from the employer? And they said, I haven't this entire time. So normally a claim is getting to me usually after about 6 months past the injury date, sometimes a year. And in that time frame, there were so many opportunities to be in touch, so many opportunities to talk that just weren't happening. So it didn't happen until it got to Voc Rehab. And then oftentimes when I spoke to the employer, the answer was, sure, we can work with them. We can work with that. We can find a way to get them back. So this is something that could have happened earlier on, saving claims calls, keeping that worker attachment, keeping the good morale going between the employer and the worker. But it all starts with that immediate contact. The second part of the duty to cooperate is suitable work. The definition of suitable work is work that is safe, productive, meaningful, and fits within that worker's functional abilities. So it is important that the employer is making suitable work available and that the worker cannot unreasonably refuse suitable work. Now, we did have the question on who the employer is, and that's really an important one, especially for this industry. And the decision on who the employer is a decision that's usually made at the time of injury and with our assessments department. So I don't have a complete answer, but I can tell you what we've typically seen. And in your industry, what we've seen is that the production house or the production company that is listed typically is the employer that's listed. So not the payroll company, not those who are writing the checks, but typically the production company. That's important because with the duty to cooperate, there is an obligation by the employer. So if the employer is not reaching out and no one else is, then the employer would be the one who would have consequences for not meeting the duty. So it's important that you are establishing a return to work program, that you're determining a person who can reach out, that the employer is aware that an injury is happening and that they are reaching out at the most practicable moment. So the next point is provide information. The employer should be providing that information. When you are having those conversations, that should be uploaded with your F7. It should be uploaded to let us know that you've reached out to that worker, you've started conversations, that you need to let WorkSafeBC know that. And the worker needs to let us know as well that they are seeking treatment, that they are in contact. All of that information should be provided to WorkSafeBC. Because again, that worker does not have a right to unreasonably refuse. So if they are in that position that they are refusing work, that needs to be communicated to WorkSafeBC. And that's the fourth point, is that the employer has to make work available and the worker cannot refuse. And they shouldn't be refusing up into the point of an undue hardship, which I believe was another question that we received. Undue hardship is the point at which is too difficult, too unsafe, or too expensive to remove the barriers so that a person can return to work. So that's going to vary from company to company. A smaller company wouldn't be expected to do what a larger company could do. And so there would be no expectation in creating positions that could be considered an undue hardship. And also when it does get too expensive to make that happen. The application of the duty to cooperate. So all accepted claims where the worker is disabled from earning full wages is impacted by the duty to cooperate. So if there is an injury and the claim has been accepted, we're going to expect that conversation. But you want to get into the habit of return to work, that when a person is injured, that you are reaching out to them. Because it is the first moment practicable. It may take a while for a claim to be accepted. But you do want, when you are uploading your forms, you do want it shown that you are in communication, that you are collaborating with that worker to help find suitable work. So the duty starts from the date of the worker's injury, or the date of psychological change, or the date of disablement. So right away from the beginning, that's when the duty is triggered. All claims after January 1st, 2022, and all decisions after January 1st, 2024 are all applicable under the duty to cooperate. And the duration of the obligation, it continues through the entire claim. So let's say you do have a worker who is only on set for 2 to 3 days. That was the length of the claim, but they get injured on the first day. So you should be contacting them from that first moment practicable, and you should be contacting them through those next couple of days and seeing if there's any place you could put them for that time period. So if there is a contract that a person is on, and you already have an agreement that you're going to work for this specific time frame, then during that whole time frame, even if there's only a week left, even if there's only a few days left, you should still be in contact. That duty to cooperate is still valid on this claim, and you should be still trying to contact that person and be in touch with that person, having conversations. The conversation should be talking about suitable work with that individual. You know, what is it that you think you can do? They should be commenting on aspects of the job. This should really be a collaboration to see what it is that they can do. And if there is suitable work available, then they should be given the opportunity to do it. Okay, so we have a true or false question, and I can see some of the chat, but I'm gonna just give you an opportunity to answer, but then I will after the pause. So true or false, you must obtain medical approval to offer suitable work. Okay, so this one is false. You do not need medical approval to offer suitable work. A lot of times we wait for a doctor to say this person can come back to work, for WorkSafeBC to say this person can come back to work, for some indicator that this person can come to work. And that is not needed in order to offer suitable work to someone. The conversation that you have with the person is enough. So the conversations you're having on what you think you can do, what is it that you can't do, allowing them to try a position, asking later if it works for them, that is the conversations and the things that we expect to see on a claim. So documentation and communication are key, but you don't need medical approval. You don't need a doctor to stamp off on it to show that that person can get back to work. It can be useful to have some type of idea of what the limitations are from a medical perspective. So you can certainly talk to the claim owner of getting more information, but you should be having the conversations with someone to see if they can do the job. And if they cannot do the job, if they are still an employee because they are still under contract, this is a conversation that may be happening along the way. This is a back and forth communication as long as the relationship exists. So you should be continuing, not only talking to that person, but continuing to have the conversation about what you can and can't do, because people will get treatment that may allow them to do more. So that continuation we will look for as well. Okay, so I'm going to turn it over to Elise to speak a little bit about the duty to maintain employment.
Okay, this is quite dry stuff that Teresa and I have learned. Dry as toast, as she says. But what we want to make sure is that you guys, we get through the material and have lots of time at the end for you guys to be able to ask the questions. I see a few questions have come up in the chat, and some of the answers that I have that I'll be speaking to may touch on those. And if they don't, we can go back at it again in at the end when we have the question period. So the duty to maintain employment really adds a legal duty for eligible employers to maintain employment of an injured worker. It applies to all accepted claims where employers and workers meet the eligibility criteria and where the worker is disabled. And what is the eligibility criteria? An employer needs to regularly employ 20 or more workers on the date of injury. That's the first criteria. The second criteria is that the worker must have worked for the employer on a part-time, full-time, casual basis continuously for 12 months. Now, continuously, what we mean by that is a worker's employment is considered continuous unless it's interrupted. And an interruption would be they resign, or they are laid off greater than 3 months with no recall date. That's considered an interruption. What's not considered an interruption is workers who have been working with the same employer on a series of employment contracts with a clear pattern of extending or renewing those contracts, layoffs with recall dates, or where the worker is expected to return to work, or any other leaves, union leave, parental leave, WorkSafeBC leave, sick leave, those type of things. Those are not considered interruptions to the 12 months. When we look at the duties of who's responsible for what, in the employer, just like duty to cooperate, the employer is obligated to offer and provide suitable work in accordance with the worker's ability. Remember when Teresa said it needs to be safe within their abilities. And when we say suitable work, we are meaning light duties, modified duties, could even mean their pre-injury duties, but we're looking at that combination of work that meets that worker's ability. And we want to make sure that we're accommodating to undue hardship. Again, that's what Teresa defined. WorkSafeBC makes that decision of what the threshold is for undue hardship. There is when we look at employers, if a worker is fit to do their essential duties of their pre-injury work, and essential duties meaning critical job demands, that's what language we used to use. If a worker is fit to do their essential duties, the employer has the obligation to return the worker to their pre-injury duty or other work that is comparable within terms of their job demands and wages. If the worker is fit to do the essential duties of their pre-injury work, the employer is obligated to offer the first available suitable work and make workplace accommodations to undue hardship. That means if somebody needs to have a stool or take tiny rest breaks to rest their injured body part, that would go on for as long as the work relationship exists. For the worker in this particular one, there isn't a lot of obligation in there. Their obligation is duty to cooperate, to make sure that they're communicating with the employer, that they're not unreasonably refusing duties that have been made available for them by the employer. They're expected to be talking to WorkSafeBC about progress and updating the employer on their abilities. And they're supposed to be letting us know if they've been terminated based on their injury. And finally, WorkSafeBC is there to help perform and decide what the essential duties would be. What is that threshold? What do we need to get them back to? They're also there to help the employer and help the injured worker determining what those functional abilities are. Quite often we send people to programs, to doctors, to physios, to chiros, all sorts of different things. Will help determine and supply that information to employers so they can meet their obligation to make that suitable work offer. We assist with return to work planning. And actually, since the law came into effect, we have several new roles at WorkSafeBC, including return to work planners and return to work specialists, helping employers resolve disputes, come to the table to facilitate the conversation and overcome some of those barriers. It doesn't take place of the obligation for the employer to have that conversation, like Teresa said, first practicable moment. We are there to help later on after everything has been done. And of course, our final thing is to determine compliance within the legislation. Okay, there's been a lot of employers that I have worked with over the years that have either refused to find suitable work and also at the other end demanded to have a doctor's note before somebody comes back to work, then just to have somebody walk in the door and be immediately fired. So in those situations, duty to maintain employment, it is deemed by WorkSafeBC if somebody is fired or let go related to the injury within 6 months, it is deemed that the employer has failed in their obligation to duty to maintain employment. It's super important with all of these things that you document, you maintain conversations with the claim owner, and that you have good HR practices. There are lots of times when people are fired and let go for reasons that have nothing to do with it. It's the job doesn't exist. There's other things that are there. They're poor performers. It's important to make sure you're communicating with WorkSafeBC and that you're documenting this and you've got the HR practices and support in the background. This duty applies to all accepted claims where employers meet the eligibility criteria. Again, 20 employees at the time of injury or 12 continuous months of part-time, full-time casual work. It applies to all wage loss claims. It does not apply, that means where people have lost time from work. It does not apply to healthcare only. Somebody might have had an injury, seen a doctor, maybe gone to physio, doesn't apply to those claims. And it lasts for as long as the relationship with the employee, with the employment relationship exists. And that's a long time. The times there are exceptions though. So if somebody, for example, the duty to maintain employment obligation ends if there has been no return to work in 2 years, or if the injured worker resigns, there's no obligation there anymore for the employer. And again, there is a little bit of a kickback. It applies to, that doesn't apply to any claims before January 1st. So if somebody was let go, may not apply. And like I said, again, healthcare only claims. This is another true or false, and I'll give it a minute just for you guys to think about it. The duty to maintain employment resets after every contract. True or false? Thanks, Nicole. It is false. In the duty to maintain employment, the answer is actually, it's a bit of a trick one. It depends, but generally speaking, it does not reset. It depends on the pattern of the contract and the pattern of employment. Keeping those people connected to the workplace is absolutely paramount. That's key. Keep them connected whenever possible. What does this mean for you guys? For situations such as multiple seasons or contracts, something like one of the situations that was posed to us, like the Good Doctor, where they have come back season after season after season. If there is a pattern where the worker has been brought back to work on a regular basis and there's expectations, it may trigger the duty to maintain employment. However, if there's another situation where contract was once, it was only for a short period of time and they were never brought back again, that obligation's not there. It's not the same. It must meet the threshold of the 12 continuous months. And 12 continuous months doesn't mean 12 individual days of work or 12 months worth of work to bundle up to that. It could mean different contracts, different combinations over a period of time. So again, it comes down to the pattern of employment with the accident employer. If somebody it has any, just like Teresa was saying, if there's any time left in a contract is ending in 3 weeks, make sure that you're making that contact as soon as practicable and offering that first suitable work that you can. If there is no suitable work, the work is done, there is no more work available, the contract is over, you may not be then obligated under this part of it. If you can't invent work, you don't need to invent work to be for this. We did get a number of questions regarding union and how duty to maintain employment impacts collective agreements and seniority is the act or the law prevails except when seniority is a factor. Meaning, union collective agreement provisions around seniority may override the duty to maintain employment. If somebody is working in a large multi-unionized site and it's in a set where there's different unions there, it's not reasonable. It may not be deemed suitable work to pull your best boy and put him into catering or driving a wardrobe truck. That's not what the expectation is. But the expectation of the employer still is to find the first and offer the first suitable work. So cross-union boundaries is not necessarily an expectation, but it is still an obligation of the employer to find this work. It is really, really important that these conversations, you're not doing these conversations, the person who's responsible for return to work or managing and overseeing claims in your organization has a conversation with the claim owner. All decisions are made on a case-by-case basis and on the individual merits of the claim. It is very hard in a situation like how you guys are in your industry, where somebody could be coming back year after year, or somebody could be having contracts of 5 minutes, a couple of days here, a couple of days there, a couple of days there, and never meet that threshold. It is really important, if you are aware of the duty to maintain employment, to ask right away and have those conversations with the claim owner. They're the ones that are ultimately going to judge if you've met the obligation. It's really hard to give firm answers in every single situation, but we'll set you up with some resources towards the end. So one, you can reach out and ask questions. You can always reach out to the claim owner and so you guys can bounce things off, or we can help navigate that for you. But the connection and communication and documentation is everything under this act. Consequences of non-compliance. Now, we know that the duty to cooperate, duty to maintain employment, it adds a legal authority to impose administrative penalties or reduce or suspend wage loss equivalency benefits. And what do I mean by those benefits? It means wage loss. That gives us WorkSafeBC and the decision makers on the claim the right to make these decisions. For the employer, it's administrative penalties potentially. For the worker, it's their wage loss that could be reduced or suspended if they are not participating in the return to work and they're not collaborating. We know that many employers do the very best they can with return to work. Those that have programs throughout the province are trying their very best. Our first choice is not to come with a big old bat and start beating people up because they're not meeting their obligations. Our approach is going to be find out information, facilitate those conversations whenever whenever we can, break down barriers, provide education. Sometimes it's the injured worker needs to understand. Sometimes the employer needs to puff up their program a little bit more, or their knowledge base of what they can do, what they should be doing. But we come in first providing support before we ever get into penalties. And WorkSafeBC has the right to adjudicate and the failure to comply. We do have a team of compliance officers at WorkSafeBC that have been set up for this. And at this point to date, there has been no penalties. And they're not expecting to necessarily have penalties. We're going to provide support, help facilitate, and support employers that way. So this is the easier part. This is the fun part. This is the stuff that Teresa and I do, besides talking about law and policy, which isn't very fun, is our department is here to help employers, to help the ActSave, to help the employers. We have many self-help tools that are online. I have sent a number of them. We've sent them off to Anna and Marat to share with you, so you have some immediate fact sheets to look at, so you have some better understanding. We also have an employer support email and phone number that you guys can be phoning to ask us questions. We don't get involved with Bob's claim or Joe's claim or whoever's claim. That's the decision maker's responsibility to make those decisions. We can't get in the way of that. Again, each claim is managed and decisions are made based on their individual merits, what comes to file, what medical is there, and whatnot. We don't get involved with that. But what we can do is next time, before Fred gets injured, we can help you set up either your program or some processes, or help you with some templates of paperwork to help you through this to meet your obligations. We do have something called early access to physio. So employers, I don't know if you're aware, but all injured workers with a sprain strain type injury, and we don't need a diagnosis, there needs to be no waiting, no doctor referral, no claim allowed on any pending claim. An injured worker, once they've made a claim with WorkSafeBC, can go see a physio for education, for pain management, and some home exercise program. One visit. That's how jazzed we are to give that early active rehab. For employers that do have a return to work program, we have more. There's no point in talking about that right now because there's a lot more to it, but there's more stuff to support the employer with those robust return to work programs. We work with individual employers to suss out some of their issues and help them come up with different things. Some employers need help with what we call a suitable work list. Other employers need more help with their timeliness around submission of forms and their communication opportunities between their injured workers and their supervisors. We have courses. We have online courses that we run every 6 months for return to work coordinators. So anybody in your organization that is responsible for return to work, following up with claims, we have a course that's available it's free of charge, done online, 2 half days. Again, we've left some information to be sent out to you guys, so you have the opportunity to find out, what do we need? What are we teaching you guys with regards to meeting your obligations for duty to cooperate and duty to maintain employment? We also have training for supervisors, leaders. We provide training on Bill 41 conversations, all of these things. And of course, engagements. We do partner with some large employers within the province to help them improve outcomes. So that's in a nutshell everything that's within our area that we can provide. Again, don't hesitate to reach out to. We have return to work specialists that man the lines Monday to Friday. They're happy to help. They're happy to enroll you into one of the courses, again, free of cost. And every 6 weeks we run those courses. There you go. More contact information.
And it looks like we do have quite a few questions that came in during the chat while we were presenting. And Maret, if you're okay with that, I'm going to launch right into those questions.
Yes, please do, Teresa.
Thank you. Okay, so the first question is, so how does this apply to gig economy, where workers work 1 day for each employer, and what if the employer is gone in a month? Good question. Okay, so we have 2 duties here. We have the duty to cooperate and the duty to maintain employment. With the duty to cooperate, if the gig was for 1 day, that's one thing. But if, let's say it was a 2 or 3 day gig, the duty to cooperate says that there should be conversations to see if there is any way that person can come back to work whatsoever. That's not a guarantee that they can, but there should be conversations. So the duty to cooperate says you have to contact them at the first moment practicable, and that should be uploaded by the employer onto the portal for WorkSafeBC. Now, the duty to maintain employment might not be triggered. If it's a gig economy and a gig worker, maybe they haven't had that repetitive pattern of employment that equals a year. However, I would caution, and I have to caution, that I would be careful that you're not firing someone because they're injured, because even though you may not trigger our legislation, you could trigger human rights or employment standards or other legislation. Next question. And how does it work with a production company that only exists from 6 months to a year. This is the majority of productions here in Vancouver. In a long-standing recovery time, the employer will be gone before the claim is over. Definitely. Again, you have the employer, the production company, if someone is injured while they are here, while there is a contract, they should be contacting the person at the first moment practicable. They should be looking for suitable work. That type of communication ongoing is expected to be there. If that person was already, if that production company was already planning to be ghost in 6 months, then that's something that was probably understood between the actors and the workers and everyone. So, you know, it's even though the claim still goes on with the recovery time, you know, that may, if they were only going to be here for 6 months, that may eliminate some of the duty there with the duty to maintain employment. However, if they come back and they had always kept that person coming in a pattern of employment, then they still may have some duties when they return to contact that person. Do you have anything to add, Elise?
No, I don't. I think you've got that one.
Okay. Do accommodated work duties need to pay the same as the job the worker had when hurt? In other words, it wouldn't be suitable for an actor to be forced to do background extra work, which pays a fraction of what actors earn. Yeah, we can't bankrupt businesses when people are in huge positions and now the only thing available is something that pays minimum wage. It wouldn't be fair to the industry or the employer to do that. So we expect for conversations to happen. We expect if there is suitable work, if the unsuitable work, meaning that it's meaningful and that it restores the person as close to their full wages as possible. If there is meaningful work available, suitable work available, it is expected that person will be offered suitable work. If there is not, and the only thing that is available is something that is less than suitable work and less than the pay, they should still be offered that work and that should be uploaded. But you aren't expected to put someone in a very small position and expect them to have an inflated salary. That wouldn't be fair.
No. Just to add to that, Teresa,
Mm-hmm.
when it comes to in the regular adjudication of claims, we top up to 90% of net. So it is not expected that if you've got a person going to a slightly less paid position that doesn't normally earn what they regularly would, WorkSafeBC will top up to 90% of net. We do have a maximum. We do have high income earners that earn more, but we pay up to that maximum amount or 90% of net. So there is some compensation for the injured worker because it's not fair that they've been injured and they're completely out of money, but it's not, you're not obligated for that to be making sure you try and do your very best. You don't have to put an actor in a lesser background extra work position.
Thank you. Okay, so if a worker on my roster is injured on another employer's site, do I have a duty to participate in the return to work process? That depends on who you are. So if you are an employer and you have a roster of people who work with you and they're injured somewhere else, that is the employer would be defined as the employer that they were working for at the time. So if they are on your roster, but they weren't injured, for you, the employer, you may not have a duty in that respect. So it wouldn't trigger the duty there. Now, if you are the employer and they were injured on another employment site, then that would be different. But from what I understand in this industry, there can be a lot of different employers. So whoever is listed as the employer, that's who we're going to be asking, are you cooperating? Are you maintaining the employment? Those questions are going to be coming directly for the employer. And can you more clearly define 12 months employment when a worker is casual on call and only takes 3 or 4 individual shifts in a calendar year, but has been employed for multiple years? Yes, what we're looking for and what we tend to look for is a pattern of employment. It's a whole lot easier in farming industries because you have seasonal crops. So you know when people are coming back. So if there's a pattern of them coming back every time it's harvest season, we can see that a little more clearly. So this one is going to be adjudicated just based on the pattern. So if you have a person that you always hire in the first week of production because of a specific job they do, if you always do it with every show that comes available, then if we can find a pattern there, then it will be expected, if it equals 12 months, that you do accommodate that person. If there is no specific pattern, like maybe I work 2 days in January doing one thing and then you sever the employment, maybe I work a month in January and then employment severed, maybe doing something else, and there's no real pattern there, then it would not trigger the duty to maintain employment. However, it does still trigger the duty to cooperate. So we still need to see conversations that you're having with this person, and that we need to see a genuine, need to see you genuinely trying to find them suitable work. Does the employer have the right to terminate the employee as soon as the employee got a notice from a doctor that they are fit to return to work? Gosh, I guess we should have told the story, Elise. It happened to someone I know on the first day they returned. She was served termination notice on the same day. Their excuse was department restructure, but she saw the posting for hiring. Then, yeah, no, that is not right. The employer does not have the right. That's what this legislation stops. If a person has been injured and they have a doctor's note that they're fit to return to work, if they're having communication that they should be going back to work, there should have been communication with her on whether she could have returned to work far before even having a doctor's note. So she should have been back to work. Them terminating her, there would be consequences. There would be a call from WorkSafeBC. There would be that, but it does need to be triggered by the employer. The employer needs to reach out to their claim owner and say, hey, I believe I was unjustly fired. I see the position. This is what's going on. WorkSafeBC will follow up because this is the exact behavior we're trying to stop. We have people who want to work, who can work, who have given their lives to this type of work. Yeah, this is not something that we allow.
Something in the act that and the compliance officers are finding is as of January 1st, if somebody is terminated and the worker feels that it's related to their injury, if they're terminated within 6 months of their return to work, that's assuming their job goes for 6 months. But if they're terminated within that time frame, it is automatically deemed that the employer failed in their duty to maintain employment. It is imperative. We provide worker education as well. There are resources and a webinar online for the workers to see and understand what their rights and obligations are, because they're also a part of this as well.
Mm-hmm. And also that reminder that even though WorkSafeBC may not always be triggered, there are things we don't always know. There are other legislation out there that do apply in situations like this. Next question. We have an employee that is off on an approved WorkSafeBC claim. They want to come back to work, but there's no medical and no claim owner assigned to the case. What is our duty? Are we allowed to take them back with no medical, no word from WorkSafeBC? It's difficult because there's no claim owner assigned to the claim, even though it is approved. That is difficult. I don't know exactly what's going on with that one, but I can tell you this, that because we're saying now with the law that you should be contacting at the first moment practicable, that's usually before there is even a claim. Like it could even possibly not become a claim. But the habit and the structure that we are trying to create here is that people are being contacted right away and you are having a discussion with them on whether or not they can return. You don't need a decision from WorkSafeBC. You don't need a decision from a doctor. You don't need medical from a doctor. All you need is to show a series of conversations between you and that worker on whether or not they can return and what position would be best. So your duty under this would be to make sure that you are in contact from that worker for the the moment first practicable, and that you are having those conversations. And if there is suitable work based on what they say they can and can't do, that you are offering it.
Just to add to that, if you feel that you need a claim owner. We do have a lot of system allowed claims. It doesn't mean that there hasn't been time loss or there hasn't been offers of suitable work that have been happening in the background, but our system auto approves claims, and there's not always, as much as there's live people looking at the claim, doesn't mean there's always somebody sitting right on it, reading everything that comes through. If you are, like Teresa said, you are absolutely do not need to get medical approval. That's nice to have. You just need to move forward with your cooperation and your conversations and looking for those suitable work. You don't necessarily need our approval or medical approval to do so. That's the purpose of the law. But if you do feel that you're having some struggles and you need some help and there's nobody helping you, you can ask for a claim owner. Usually, if you are calling into the call center or you're putting a document online asking for a claim owner to call you back to give you some help and some support with how do I manage this? Because there are some funky situations where people need some help. Please feel free to call in and ask for that help.
Now, I don't think this is a question, but it seems to be a comment that crew are basically considered day calls, not weekly, so no guarantees. Producers moving away from flats and avoiding weekly crew. So I'm only going to say to that, and I just bring that up because even though in your industry there may be rules and things that are outlined about definitions of different things, we at WorkSafeBC, if you have established a pattern of employment, things can still be triggered. So just be careful with the crossing there, because we may have obligations under our legislation that you may not be used to following because we didn't have that before where we had the legislation, but there is an expectation if there is a pattern of employment that that extends to 12 months, that regardless of what you title the person as, we're going to still see it as 12 months of continuous employment. Okay, will the information shared in this webinar be shared in some form afterward? I would like to forward it to the rest of our joint health and safety community. This has been recorded and is being recorded, so I definitely hope that you will share this as much as possible. And not only that, on WorkSafeBC.com, we did a webinar in November 2023 on Bill 41, and it also includes a list of frequently asked questions that you may also find very useful for sharing. Each season of a specific TV series is usually set up as a different company that is wound down at the end of each season. Show name season 1, show name season 2. If a crew member is injured on season 1, does the duty carry on to subsequent seasons, even though they are technically different companies? Very good question. And it's one of those, it depends, because it gets very complicated. Your industry gets very complicated. But let's break it down just a little bit. One, you always have that duty to cooperate. That is triggered right away. So there should be conversations, there should be communication that if suitable work is available, whether it's in this season or next season, if you are the production company that is running each season, or, you know, they're still your employee, you should be looking for the most practical work for them. Unless there's a contract that says I was only working season 1 and that's it. If you have a contract with me for just that first season and I don't have a pattern of employment where you were bringing me back every single year, well, then you may not owe me a duty to maintain my employment. However, if there was that, even though even though it changes so much, if the employer didn't change and you're in control of the other seasons, then you should be bringing me back. You should be bringing me back. And at the least, the duty to cooperate is always triggered. So there has to be conversations. There needs to be communication. The worker, if should be communicating with us. It's not going to be a one way. So you should be asking about suitable employment. They should be asking you questions about suitable work and reporting your answers to WorkSafeBC. So it needs to be some collaboration there. So it really depends with this particular question, because I need to know if each, when you say set up as a different company, is the company ending? Is the relationship severed? And also, was that person going to work each season? Did they have a role where they'd be working each season? And have they done that for a year? So it depends. Did I miss anything with that one, Elise? I feel
No,
so
I think you got all of that one.
okay.
Keep going. I just see there's 11 below what I can see on the screen. So we'll just keep
Okay.
plugging through until we get cut off.
Absolutely. I think this is the most useful to be able to apply it to your industry. The challenge is the department that is hiring. If the individual cannot perform the duties required, so you've got production and then the department. Injury standard is an injury in any injury is to be reported to the supervisor PM in production within 24 hours of incident. Okay, that is a good standard that it needs to be reported right away, and there needs to be communication right away. I see the challenge there between the department and what the individual can and can't do, and maybe it's reported to someone else other than the employer, but there has to be a point person in the production company. There has to be a point person that once they figure out that an injury has taken place, that they are immediately making contact. There definitely is challenges when people are in different payrolls and different rosters, and there's so many hands touching it. But when WorkSafeBC is applying this legislation, they're looking directly at the employer. So if a call didn't get made, if cooperation isn't happening, if employment isn't maintained, even if the production company had no clue that the person was fired because of what happened, they are still held responsible because they are the employer.
I think the next question,
yes,
it jumps down to Laurel's.
Okay. Can an employer require medical approval if they are concerned about the employee pushing through an injury and making it worse? You get both sides of the coin, right? You get people who absolutely don't want to come back to work, and then you get people who really, really want to work. It doesn't matter if their limb is like almost detached. They're just trying to get back to work. And we appreciate people who want to get back to work. Can you require medical approval? Yes, you can. You should be having conversations with that person. You should be having conversations about what part of their body they injured. If they injured their leg and there is a seated position, where you feel like they wouldn't at least exacerbate the injury, if that person's willing to do it, you could try it and see how it works. However, if it gets to the point that it's just looking really unsafe and you're really just uncomfortable with the whole thing and your gut feeling says, yeah, he might need some real treatment here, upload all of that. You need to upload the conversations. You need to upload that he kind of paused a little bit when you were talking about certain things. You need to upload your feeling and just let them know that you are maintaining that duty to cooperate. The duty to cooperate, if you're calling him weekly or bi-weekly or whatever you guys have agreed upon, and you're showing that, and you're showing that you're trying to maintain the employment, that effort is going to be considered. So if they don't have medical approval and you feel like they're pushing through an injury, if your gut is saying, I don't really feel comfortable with this, document all of it. Speak to the claim owner if you can, and document everything.
Just something to add on that. There are a lot of employers that have programs that don't have programs. This is something that, you can do on a case-by-case basis. Quite often it's part of an HR practice for us to bring people back to work, even on when they're super keen. The conversation and the collaboration at the time you're bringing them back and ongoing. You don't just set them free to go crazy carrot somewhere. Maintain that contact, set expectations, modify the plan, be in control of whatever that suitable work offer is. But you are more than, it is your program. It is you're allowed to ask for these things. We just don't want doctor's notes to be barriers for people to be coming back to work. Because if you're waiting, there could be put you in conflict with the duty to cooperate, to have those conversations. Don't wait.
So does the first contact include filling out the F7 with the first aid attendant, or does it have to be a different conversation with someone else? And who on the production company would these conversations happen with? Many productions are small and don't have a safety department that may have skills dealing with injured workers. Great question. So with the duty to cooperate, you're contacting people at the first moment practicable. So that may be before the F7. If the F7 is with the first aid attendant, so that's who the person would go to as soon as they're injured to let them know. That could be the first conversation. You could definitely upload your F7 and it says that this worker spoke to the first aid attendant, and this is the suitable work we have available. And you can definitely upload all of that. But what we want to see is an ongoing conversation and an ongoing collaboration, because that first moment, it may not be an opportune time. It may not be the first aid attendant may not have all the information. So it's really going to depend on what kind of information your first aid attendant has when filling out and uploading that F7. And we are aware, a lot of companies don't necessarily have that first aid return to work person available, but there has to be a point person. There has to be a point of contact, because again, you can put your trust in the first aid attendant. You can put your trust in other people to make sure that they have communication and collaboration. You can put your trust in the unions, all of that. However, if that duty to cooperate is not made, and if that duty to maintain employment, if they are fired without you knowing, you could face consequences for that and not even have been a part of it, because you are the employer. And this is a legislation that is between the employer, the worker, and WorkSafeBC.
Hey, Teresa and Elise, we're coming up to the end, so unfortunately we have to cut off the questions, but it was an amazing session. These were just some pre-populated questions, but I feel we've answered them. So these are some of the resources that we're going to be sending out to everybody, along with the recording of this webinar. So you can look forward to that in your mailbox. And yeah, so we'll be sending you the webinar, a list of resources. Our next webinar currently is on March 19th. This is Code of Conduct. This will be presented by Good Night Out. And what I would ask for now is if you guys could give us your feedback. You can aim your phone at this QR code, and you come up with just a few questions. It really helps us to tell us if you've enjoyed this webinar, if you felt it's useful, if you feel there's anything that we could improve with that. Do you have anything to add, Elise or Teresa?
No, please don't hesitate to contact us if you have any questions, any further questions. We'll do our best to get back to those other ones that were left behind, those straggling questions. We'll do our best to answer those and provide them back to the group so you guys have them.
And that's exactly what I was going to say. So thank you very much for having us. We loved fielding the questions, and we love being here with you today. Yeah, it appears people really have enjoyed looking at the chat. People felt there's lots of great information that they felt it was really useful to them. So I'm so happy you were able to come out and do this webinar for us.